Hello everyone, and welcome to another video. Today we're going to continue talking about more powers of the legislative branch of the government. This video is going to focus more on the powers of investigation and the power of impeachment. So let's get right into it. The power to investigate. Congress has the power to investigate, to inquire into or inform itself on any matters that fall within the scope of its lawmaking authority. The authority to do so is implied by the Constitution's grant of the legislative power to Congress in Article 1, Section 1. Both the House and Senate exercise that power through the standing committees and their subcommittees, and often through special committees as well. Senator Joseph McCarthy and his aide listened to proceedings at a Senate investigation in 1954 into alleged attempts to obtain an Army Reserve officer commission for McCarthy's political ally. Both houses may choose to conduct investigations for any one or a number of reasons. Most often, those inquiries are held to gather information necessary to the framing of the legislation, oversee the operations of various agencies in the executive branch, focus public attention on some particular matter, expose the questionable activities of some public official or private person or group, or promote the particular interests of some members of Congress. Notice that the second of these motives, oversight, is a little noted but quite important aspect of the constitutional system of checks and balances. Note too that Congress is more inclined to exercise its oversight function when one or both of its chambers is controlled by the party that does not hold the presidency, most recently in 2013 and 2014. Executive powers. The Constitution gives two executive powers to the Senate. One of those powers has to do with appointments to office, and the other with treaties made by the President. Charles Chuck Hagel speaks to troops during a visit to Afghanistan, his first trip as U.S. Secretary of Defense. Hagel was confirmed to the position in 2013 by a vote of 58 to 41. Appointments. All major appointments made by the President must be confirmed by the Senate by majority vote. Each of the President's nominations is referred to the appropriate standing committee of the Senate. That committee may then hold hearings to decide whether or not to make a favorable recommendation to the full Senate for that appointment. When the committee's recommendation is brought to the floor of the Senate, it may be, but seldom is, considered an executive or secret session. Pictured here is Pete Buttigieg. Was most recently confirmed to the President's cabinet as the Secretary over the Department of Transportation by President Biden. The appointment of a cabinet office or of some other top member of the President's official family is rarely rejected by the Senate. The Senate has rejected only 12 of more than 600 cabinet appointments. The most recent rejection came in 1989 when the Senate refused President George W. Bush's nomination of John Tower as Secretary of Defense. More commonly, the President will withdraw a nomination if the Senate sends signals that it will reject the nominee in a confirmation vote. For example, President George W. Bush withdrew the nomination of Harriet Miers, his White House counsel, to the Supreme Court. Bush later nominated Samuel Alito, who was confirmed by the Senate. So, a lot of times, if a president thinks that his appointment to the cabinet isn't going to pass the Senate, they'll just appoint someone else. They'll just move on. As it says there, since we've had a president in the cabinet, there's only been 12 of more than 600 appointments that have been rejected, so this does not happen very often. Congressional confirmations of President Barack Obama's cabinet members have been somewhat contentious and partisan. For example, during the Senate confirmation hearings for Timothy Geithner as Secretary of the Treasury, the issue of past tax payments was raised, causing some controversy. Still, his appointment was eventually confirmed, and he served from January 2009 until January 2013. President Obama's nominee for Secretary of Defense, Chuck Hagel, faced a congressional filibuster during a partisan battle over his confirmation in 2013. Hilda Solis, nominated for Secretary of Labor, faced a long and combative confirmation process, but was eventually confirmed. There have also been several recent failed nominations, including Bill Richardson for Secretary of Commerce and Tom Daschle for Secretary of Health and Human Resources. It is with the President's appointment of federal officers who serve in the various states, for example, U.S. attorneys and federal marshals, that the unwritten rule of senatorial courtesy comes into play. The Senate will turn down such a presidential appointment if it is opposed by a senator of the President's party from the state involved. The Senate's observance of this unwritten rule has a significant impact on the President's exercise of the power of appointment. In effect, this rule means that some senators virtually dictate certain presidential appointments. So I know that can seem confusing, but there is this policy that it's unwritten, it's not like officially a rule, but if certain people do oppose a presidential appointment, the president will move on and appoint someone else. Treaties. The president makes treaties by and with the advice and consent of the Senate, provided 2/3 of the senators present concur. For a time after the adoption of the Constitution, the president asked the advice of the Senate when a treaty was being negotiated and prepared. Now the president most often consults with members of the Senate Foreign Relations Committee and other influential senators of both parties. The Senate may accept or reject a treaty as it stands, or it may decide to offer amendments, reservations, or understandings to it. Treaties are sometimes considered in executive session. Because the House has a hold on the public purse strings, influential members of that body are often consulted in the treaty-making process as well. Impeachment. The Constitution provides that the President, Vice President, and all civil officers of the United States may be removed from office on impeachment for and conviction of treason, bribery, or other high crimes and misdemeanors. A close reading of those words suggests that the framers expected that only serious criminal offenses, not political disagreements, would lead to impeachment. Politics has nevertheless been at the root of most impeachment controversies. Most of the time, whenever impeachment is being considered, there are usually some political disagreement at the root of it. As I've said before, many presidents have had articles of impeachment brought up against them. However, unless the articles of impeachment pass the House, it doesn't go anywhere. President Bill Clinton appears at a news conference after an impeachment vote by the House. Clinton was acquitted on the 2 articles of impeachment, perjury and obstruction of justice. Okay, here's a graphic that goes over some times that judges were removed by impeachment. Most of the time, whenever we hear about impeachment, we think it only applies to the president and vice president, but any elected official can be impeached. Now, I'm not going to go over this chart with you. If you are curious about it, you can pause the video and take a look. But just know that any elected official or just official in the government can be impeached. Impeachment. The House has the sole power to impeach, to accuse and bring charges. The Senate has the sole power to try, to judge, to sit as a court in impeachment cases. Impeachment requires only a majority vote in the House. Conviction requires a 2/3 vote in the Senate. The Chief Justice presides over the Senate when a president is to be tried. The penalty for conviction is removal from office. The Senate may also prohibit a convicted person from ever holding federal office again, and he or she can be tried in the regular courts for any crime involved in the events that led to the impeachment. To date, there have been 19 impeachments and 8 convictions. All 8 persons removed by the Senate were federal judges. 3 presidents have been impeached by the House: Andrew Johnson in 1868, Bill Clinton in 1998, and Donald Trump in 2020 and in 2021. The Senate voted to acquit all three men. That is, it found them not guilty. The 2021 case, as of the time that I'm recording this video, is still pending. Now, you might be wondering, why isn't Richard Nixon on that list? Well, Richard Nixon resigned from his presidency before he could be impeached. There are a lot of situations that surround that event. He was never impeached because he resigned before he could be impeached, and then the reason that they did not pursue the impeachment was because his vice president, who took over whenever he left office, gave Nixon a full pardon. So that is why Nixon was not then impeached and had to face trial in the Senate, because he was given a presidential pardon. Andrew Johnson. The unsuccessful attempt to remove Andrew Johnson grew out of the turmoil that followed the Civil War. Mr. Johnson had become the nation's 17th president when Abraham Lincoln was assassinated in April of 1865, and he soon became enmeshed in a series of disputes with the radical Republicans who controlled many houses of Congress. Many of those disagreements centered around the treatment of the defeated Southern states in the immediate post-war period. President Johnson tried to carry out the conciliatory Reconstruction policies favored by Abraham Lincoln. Policies that Mr. Lincoln has summarized in these memorable words in his second inaugural address on March 4, 1865. With malice toward none, with charity for all. The radical Republicans supported a much harsher approach to Reconstruction. Matters came to a head when Congress passed the Tenure of Office Act over the president's veto in 1867. President Johnson's violation of that law triggered his impeachment by a House bent on political revenge. The Senate fell just one vote short of removing him from office. Bill Clinton. Bill Clinton was impeached by the House in 1998. In proceedings steeped in partisanship, the House voted 2 articles of impeachment against him on December 19th. Both articles arose out of the president's admitted inappropriate relationship with a White House intern. The first article charged the president with perjury, that is, lying under oath. The second article accused him of obstruction of justice because he had withheld information about his affair with the intern. Members of the House who supported the articles of impeachment contended that the acts of lying under oath and of withholding evidence were within the meaning of the Constitution's phrase, other high crimes and misdemeanors. Therefore, they argued the president's immediate removal from office was justified. Their opponents argued that the facts involved in the case did not justify either charge. They insisted that, while the president's conduct was deplorable and should be condemned, that conduct did not rise to the level of an impeachable offense. Many of them pressed instead for a resolution to censure the president, that is, for a formal condemnation of his behavior. The Senate received the articles of impeachment when the new Congress convened in 1999, and it began to sit in the judgment of the president on January 7th. Other powers. Congress is a legislative body. Its primary function is to make law, but the Constitution does give it some other chores to perform as well, such as constitutional amendments. Article 5 says that the Congress may propose amendments to the Constitution by a 2/3 vote in each house. All 27 of the amendments thus far added to the document have been proposed by Congress. Article 5 also provides that Congress may call a national convention of delegates from each of the states to propose an amendment, but only if requested to do so by at least 2/3 of the state legislatures. No such convention has ever been called. In recent years, several state legislatures have petitioned Congress for amendments, among them measures that would require Congress to balance the federal budget each year, prohibit flag burning, permit prayer in public schools, outlaw abortions, impose term limits on members of Congress, and prohibit same-sex marriages. Electoral duties. The Constitution gives certain electoral duties to Congress, but they are to be exercised only in very unusual circumstances. The House may be called on to elect a president. The 12th Amendment says that if no one receives a majority of the electoral votes for president, the House, voting by states, is to decide the issue. It may choose from among the 3 highest contenders in the Electoral College balloting. Each state has but one vote to cast, and a majority of the states is necessary for election. The Senate must choose a vice president if no candidate wins a majority of the electoral votes for that office. In that situation, the vote is by individual senators, with a majority of the full Senate necessary for election. The House has had to choose a president twice, Thomas Jefferson in 1801 and John Quincy Adams in 1825. The Senate has had to pick a vice president only once, Richard M. Johnson in 1837. The 25th Amendment provides for the filling of the vacancy in the vice presidency. When one occurs, the president nominates a successor, a replacement, someone to fill the vacancy, subject to a majority vote in both houses of Congress. That process has also been used twice. Gerald Ford was confirmed as vice president in 1973, and Nelson Rockefeller in 1974. So these powers do not come up very often. They are important functions if these situations were to come about, but it is not something that you're going to hear about very often. Just looking at that 1973, 1974, 1825, 1837, these have only happened a mere handful of times in our entire history. Okay guys, that's going to be it for this video. If you have any questions, you know how to get a hold of me. I hope everybody's having a great day, and I'll see you again real soon. Bye.